society, in the internet, media, so all over, everything is becoming more and more transparent, and of course everybody is coming more and more curious about not only simple things in life, but also perhaps more interesting and legal things in life. So it is something that you and I have the right to know about public authorities, how they do their decisions. We can go and ask, and we have the right to receive a reply. It is something that has been written in the conventions of the Council of Europe, but also, for instance, in the European Union Fundamental Charter of Fundamental Rights. It is a good administration, that an administration gives an answer to a citizen, and it also involves the access to information. One should perhaps distinguish an information that is already there, to ask information that already exists, from the information that perhaps needs to then be produced or explained or to analyzed. And this is of course more complicated, and one doesn't have always right to ask some authorities to provide for them something that does not exist there yet. There is also of course information that might be classified as secret or confidential for certain purposes. And this is, of course, a more complicated matter. How far does this access go to this kind of information that might be confidential? And we are sitting here at the court, we are dealing with court issues, and of course one of the questions is how far goes the access to, for instance, the court files, to every ordinary people, but also to, for instance, journalists. How much can they take from the court files of an ongoing case and reproduce it or report it in their journalistic activities? To define a public interest is a very, very complicated task. The European Court of Human Rights has been faced with this task many times. It has been faced with this task many times in questions concerning the freedom of expression. The freedom of expression, for instance, of journalists to report on criminal cases. And every time the court is asked to answer these questions, there should be a balancing with other rights that may be involved. For the court, it doesn't matter if the person is coming to the court because he or she thinks that his or her freedom of expression has been infringed, or whether he or she thinks that his private life has been infringed. So the court is doing the balancing in the same way, and the outcome should be the same. It doesn't matter which will be the issue. This means that a very careful balancing needs to be made between these two rights often. And there are, of course, also other principles involved. The fair trial, the presumption of innocence, of course, also the proper functioning of the justice system, the authority and impartiality of justice, whether this information, when it's published, will influence, for instance, the decision-making of judges, either professional or lay judges, or both, depending on the case. So there are very many tricky factors. But of course, above all, one must remember that freedom of expression is the cornerstone of a democratic society. And journalists are considered also, and freedom of expression is considered as a public watchdog by the court itself many times. And any restrictions from this freedom of expressions must be very strict and must be very well reasoned if there are any restrictions and exceptions for this. On the other hand, if somebody is using unlawful materials that have been actually important to be secret, to be kept secret, for instance, as long as the investigation is going on, then, on the other hand, the reasons to reveal this information must be very strong, and there must be really this public interest. Public interest can be already there. It means that there is already discussion going on in the society, and people are interested to learn more about For instance, there is already a case. We know that there has been a murder case or a very grave accident, and people know about it, and they want to know more about it. They want to know more about also the persons involved. They have the legitimate interest to know about it. And of course, the press has not only the right to provide them with the information, but the freedom of expression covers also information that may not only always be nice, that may be shocking, that may be disturbing. This is also covered part of the right to freedom of expression and the right to know about things. But on the other hand, of course, there is privacy life, the privacy of these people, as I said, presumption of innocence. The journalists cannot take place of the court. They cannot judge themselves. Court is the one who has the law and the facts and needs to apply these facts on the law and interpret the law. Of course, the journalists can give the information, but they cannot decide it. And there is also very important that the court helps the journalists, that they give the information when they are allowed to do that, when it's possible to do that already, when it's objective information. For instance, in many countries, prosecutors have the right to make press releases about the cases, to give the information, but at the same time not to jeopardize the investigation and not to jeopardize maybe also the rights and even the life of others who are involved in this case. Also, public interest may not yet be there, but the journalists may invoke the public interest with publishing something, and then the debate starts. This would be also one possibility. Of course, there is more public interest to it if it's something that is, for instance, about the functioning of the justice system or the functioning of the state. If something is not going well, and we would like to have more information about it, and if this debate helps to improve the situation, to reveal some problems, then of course it's a very important public debate. Or the public debate is more sort of say allowed or relaxed when it's public figures. When it's public figures. On the other hand, when the person is not a public figure, then the private life might be some instances more protected than for the public figure who is anyway there, or public official who does his functions and needs to do something, and people want to know about it. But what is important is that the court has distinguished between public debate as such and scandals or gossiping or some information that has nothing to do with this public debate, which is just there to urge for some more scandals instead of really helping to solve the situation. And there sometimes the European Court of Human Rights has said that there has not been a violation of freedom of expression in certain cases where the national jurisdictions have found that it has just gone a bit too far. There has been discussions, for instance, how much allow cameras in the courts, how much can actually be reported from the cases, hearings of the courts. And of course, the hearings are usually public, unless there are overwhelming interests of private life that prevail, or minors are involved, for instance. Then the court can close the hearings for the public, but usually they are public. And usually the presiding judge is to decide if there is a request, whether it can be filmed or not. And sometimes it has even been suggested by the Consultative Council of European Judges that these films may be used, or filming may be used sometimes for a very important procedures, historical processes, for instance, for an education purposes. But there again, both sides need to remain on their roles and need to understand what is their function, that the public and the society and the journalists cannot decide cases, that it is, of course, the judges who decide it, that it cannot create a show out of it, but on the other hand, that the public has the right to be informed what is going on. And as soon as this is clear, as soon as this understanding is there, I think it will help already quite a lot. I would like to quote the Inter-American Court of Human Rights, called sometimes our sister-brother court, and it's very interesting what they have said in one judgment. They said that the justice cannot be sacrificed for the sake of mere formalities, as long as, of course, a suitable balance is there between justice and legal certainty. And this is something that we have to keep in mind every day. And then maybe to quote another eminent source, the Pope Francis, who visited also the Council of Europe. And I think this is really the core, what the court and what the human rights is about. The centrality of human person means, above all, allowing to express freely their individuality and their creativity, both as individuals and also as peoples. And this is what all this access of information, freedom of expression and privacy comes about.